Good afternoon and welcome. My name is Leslie Horton and I'll be presenting today's session alongside my colleague Anne Morgan. I have worked for the SRA for 6 years, primarily as an investigation officer and lastly in assisting the design of the authorisation function.
Thank you, Leslie. Good afternoon. My name is Anne Morgan and I am the SRA ABS manager. I lead a small team responsible for implementing the processes and procedures to enable the SRA to authorise and regulate ABS firms.
Thank you, Anne. So moving to today's agenda, I want to begin today by discussing authorisation, the unit in the SRA which will be primarily responsible for authorising entities and individuals to practice. After briefly discussing the introduction of my SRA, Anne and I will discuss the key changes that are being introduced, including ABSs and changes in the authorisation of recognised bodies. We will finish by setting out the timelines for change and summarising the key message we would like you to take from today. We'll also be asking 3 polling questions during the session, and there will also be an opportunity at the end for you to put questions to us. Anne, I think we have a polling question coming up now.
Yes, we do. Thank you, Leslie. Our first polling question is with respect to alternative business structures. We're interested in how many of you may wish to apply. So the question that will be appearing on your screen now, is your firm already considering applying for authorisation as an alternative business structure? If you could please vote now. Okay, that's interesting. So we've got a large proportion of your votes are saying that no, you're not interested in applying for alternative business structures. That's very useful and we'll come on to some more information about that later. Back to you, Leslie.
Thank you, Anne. Before introducing you to authorisation, I'd like to share with you the whole of the SRA structure. You'll be able to see that there are 3 key functions. These are authorisation, which I will be speaking to you about in more detail, supervision, which you will have primary contact after authorisation, and our legal and enforcement team. You will notice that at the heart of our structure is our risk centre. This reflects our move to risk-based regulation. Risk will be the centre of everything we do. So moving now to look at more detail at authorisation. The authorisation function will be responsible for the majority of the application-based decisions made in the SRA. Our purpose will be to provide a robust decision-making process, working closely with colleagues in other functions, and to ensure that we will only approve applications which are merited, and we refuse to authorise people or firms which we think pose an inappropriate risk. Authorisation will process and manage much of the pre-existing applications that you are familiar with, and will also be processing and managing the new applications generated as a result of changes to the regulatory framework and our rules. Currently, much of what we do will sit within the operations unit, which you can see more detail about on the next slide. This slide here will summarise the differences between the operations and exceptions function. You can see there that the operations unit will deal with the work already processed within our current operations and caseworking and applications team. Much of that work will be pre-admission work. Our exceptions team will make higher level decisions regarding more complex applications, including applications for alternative business structures. Applications dealt with by operations and exceptions will be received through my SRA, which brings us on to our next slide. My SRA will be the gateway for interaction between the regulated community and the SRA. Also, those people wishing to have authorisation will also be able to submit applications online. You will shortly be sent your password to my SRA and you will be asked to access your profile and confirm your details. The purpose of my SRA is to allow you to take control of the information held by us about you and your firm. We are hoping that the introduction of my SRA will be the start of a more fluid engagement between the regulated community and the SRA. Further information about the online gateway can be obtained on our website, and you may also wish to view our webinar recorded on the 10th of June, which provides further details about my SRA and the services you'll be able to access. But for a quick overview of those services, you'll see this next slide which shows that all our applications will be online by October 2011. My SRA will also provide instant 24-hour access to your data. You'll be able to see your practicing certificate online, and you'll also be able to track the progress of your application. You'll also be able to make payments online, and we're hoping that all of this will prove significant administrative cost savings, which the SRA can then pass on to you as a profession. Please note that when we say that all applications online, it means that we expect primarily that our contact with you will be online, and that we will only accept manual applications in exceptional circumstances, for example where reasonable adjustments are needed. So, to set all of these changes in context, it's helpful to remind us all of the move by the SRA to outcome-focused regulation. OFR means we are changing the way in which we interact with regulated entities and individuals. There will be more emphasis on you and your firm managing and minimising risk. Firms will also have the flexibility to decide how outcomes can be achieved. These outcomes are set out in the SRA handbook, which I'd urge you to take a look at as soon as you're able to. And there will also be a risk-based approach to our focus and decision making. In respect to the latter point on risk, and also about you and your firm minimising risks, we'll talk about compliance officers, which I'll speak to you about later. So moving on, what does outcome-focused regulation mean in an authorisation context? Well, firstly, our low-risk activity, we have introduced automation. This is what we're talking about in terms of my SRA. So those low-risk activities like student enrolment, which has recently gone online, these will be an almost low-touch process in which applications are validated and approved online. 70% of our recent student enrolment has already been approved online, and that's been over 400 applications. This will leave the exceptions function to focus on high impact and high risk areas. What will that mean in practice? Well, firstly, there'll be closer scrutiny of some cases. We'll take a wider investigative approach, which can mean we have more of a dialogue with some firms prior to authorisation. The risk strategy which we'll undertake will mirror our approach in supervision, and we'll be assessing the firm structure and strategy as well as individuals. We will also be introducing a new suitability and vetting test, which Anne will talk to you about later. So Anne, tell us more about the suitability test.
Okay, thank you, Leslie. Okay, so the new suitability test, which is in our draft handbook, which you can see on our website, is replacing our character and suitability guidelines. It's a very short document of about 9 pages, and you'll see from your slide there, it starts at page 394 of the handbook. It will apply to all from the summer when we are designated as a licensing authority for ABSs, which means that role holders, including compliance officers, owners and managers, and including those managers of recognised bodies, will now have to comply with the new suitability test rather than the old character and suitability guidelines. It's split into 2 parts, part 1 being the majority of the questions which are applicable to all role holders, with part 2 being specifically about the status and suitability as corporate role holders in charities and in corporate bodies. The test itself covers very much the same sort of areas as the character and suitability guidelines: criminal convictions, behaviour exhibiting discrimination, dishonest behaviour, financial mismanagement and directors' disqualification. However, our application form has been more specific when we've designed the questions for the suitability test, and the suitability test itself provides far more guidance as to what our response will be in respect of specific issues and whether or not we would be minded to refuse or consider an application despite issues being there. Part of the suitability test brings us on to vetting. What is vetting? Well, it's a method of us being able to verify information which we're given via the authorisation process and predominantly through the suitability test questions. It's effectively a form of background checking and is something that we've needed to bring in with regard to the implementation of alternative business structures and existing risks within the traditional regulated community which demand greater scrutiny. So, for example, things like the organised crime issues we've experienced in the past, inappropriate funding and unsuitable individuals trying to enter the legal profession. It's especially relevant for non-lawyer owners and interest holders, but is already an important part of the modern regulation. Providers of databases and the ability to commission more detailed reports on individuals using public domain information and checking registers for terrorism, politically exposed individuals and crime activity will all form part of the vetting that we will undertake. Now, I mentioned compliance officers when I was talking about the suitability test. So let's talk a little bit about them. The role of the compliance officer is integral to our approach to self-regulation and our ability to be an OFR-based regulator. It enables us to have an effective communication between us and you as the firm we regulate, and allows us to focus our input and for it to be effectively interpreted and implemented within a firm, but also to allow us to concentrate on higher risk firms. At all times, a body must have an individual who is designated as the Compliance Officer for Legal Practice and the Compliance Officer for Finance and Administration. Now, I'll come on to a bit more information about the compliance officers in a moment, but we see this as an opportunity for us to ask you a question. Is your firm already planning for the requirements for nominating a Compliance Officer for Legal Practice and Finance and Administration? We'd like you to vote now so that we can get an idea of how many of you are already preparing. Okay, so we're starting to get the results now, and it's encouraging that around 90% of you are actually preparing now for these nominations, which is really great. I'm going to go on to a little bit more information about the compliance officers, but I would say that for those of you that do want some more information about these roles and the SRA's approach to regulation using these roles, there will be a further compliance officers webinar on the 7th of July. So the Compliance Officer for Legal Practice must be a lawyer and authorised in one or more of the reserved legal activities. That's not necessarily to say that they have to be a solicitor, and particularly for alternative business structures, that is relevant. They can be a manager or they can be an employee of the firm, so we are trying to provide some flexibility around these roles. They must be designated and approved by the SRA, and we'll come on to that in a moment, but for recognised bodies, that is around the nominations that will take place in the new year, and as for alternative business structures, it will form part of the application process. Their responsibility is to report material failures to comply, and they are there to ensure compliance with the terms and conditions of authorisation, except the accounts rules. And that brings me on to the Compliance Officer for Finance and Administration, who is there entirely to help the firm comply with the SRA accounts rules. They do not need to be a lawyer. However, we will be looking for suitable experience to ensure that they are able and competent to carry out their role. In terms of the approval process for compliance officers, we will be looking at implementing the suitability, and we will undertake vetting checks on those individuals that you nominate or apply as part of the alternative business structure process. We will be considering the seniority of those individuals within the context of the firm and ensuring that they have the status and the capability to provide effective oversight. We will look at the governance structure and the arrangements within the firm to ensure that issues can be reported up to the management. And we will be looking to the management team of the firm to ensure that the two compliance officers can fulfil their roles effectively. So in light of that information, we'd like to ask you a further question. Do you feel that your firm can achieve an effective implementation of the compliance officer arrangements without difficulty? Okay, so we're just waiting for that. You can see the question coming up, and we're just waiting for the poll to come up on the screen. So if you could vote now for me, please. That's really encouraging, as again, 90% of you believe that you can implement these requirements without difficulty, which is really encouraging. Now, moving on to authorised roll holders, of which the compliance officer posts are two, but authorised roll holders going forward are also the terms used to describe managers and owners. We do provide the facility for deemed approval of a manager or an owner who is also a solicitor with a current practising certificate. However, there is no deemed approval for the compliance officers. To qualify for deemed approval, there must be no conditions on the person's practising certificate or authorisation as appropriate, preventing or restricting them from being a manager, owner or interest holder. The SRA must be notified using the forms that will be online in advance of the person becoming a manager or owner, and the SRA must not have withdrawn its approval at any time under Rule 17 of the new code. From March 2012, the approval process for current managers will be passported, but all new managers, owners and owners of firms, whether recognised bodies or ABS, will need to be approved by the SRA. Now I'm going to hand back over to Leslie, who's going to take you through the Certificate of Authorisation.
Thank you, Anne. Anne's spoken in some detail there about the regulation of individuals, and I just wanted to speak to you for a few minutes about the regulation of recognised bodies, a change that you'll all need to be aware of. In October this year, it will be the last annual renewal exercise for your recognition, and in March 2012, recognised bodies will be issued with a Certificate of Authorisation instead. The annual renewal exercise will be replaced with an annual reporting process together with a process in which we will collect fees from you, and it is envisaged that these processes will be through the MySRA system that we talked you through earlier. We are still finalising the certification exercise, and we will be able to communicate our plans to you shortly. The annual reporting exercise is also currently under design and will be the formal process for clarifying the data that we hold about your firm, and we may also wish to seek additional data which will help be refined by our risk-based approach. A point to remember here is that the annual practicing certificate renewal exercise will continue as normal, although this will be through an online process through MySRA. And a point to remember, as of the 31st of March 2012, all recognised sole practitioners will become recognised bodies. So whenever you see references to recognised bodies in our SRA handbook, this will also include you as a recognised sole practitioner. Now Anne is going to speak to you in more detail about alternative business structures.
Thank you, Leslie. Alternative business structures, or licensed bodies, will be brought into the legal profession once in October of this year, and the SRA, as you will all know, has applied to become a licensing authority for alternative business structures. To be licensed, a body, which can be any type of body, so it could be a partnership, an LLP or a company, must be approved by an approved regulator to carry on one or more of the reserved legal activities. The body must have at least one lawyer manager and one non-lawyer manager, and it must provide one reserved legal activity. By reserved activities, we mean the right of audience, the conduct of litigation, reserved instrument activities, probate activities, the administration of oaths, and the provision of immigration advice and services. So if you're considering being an alternative business structure, what can you start to do in terms of preparing to apply? Well, you can most certainly get to grips with our new handbook, in particular the principles, the code and the authorisation rules. The code sets out how we expect you to meet your obligations as a regulated entity, and the authorisation rules in particular will set out how the authorisation process will take place. If you're not already a recognised body, then you'll need to consider what reserved legal activities you want to offer. But all firms will need to undertake some form of business planning activity. Whilst we don't ask for business plans as part of the application process, we do expect by some of the information that we request that some sort of business planning will have taken place. We expect to be able to be given information on estimated turnover, profit and loss, and cash flow forecasts. We will also expect to be able to understand what your growth plans are for the first 3 to 5 years after authorisation. Governance structures and management structures, and also the corporate structure of your proposed organisation, are also things that you can start to consider now and start to plan for. We'll be interested to understand exactly where the COLP and the COFA sit within the organisation. That's not to say that they have to be separate individuals. They can be the same person, depending on the size of the organisation. We're interested to understand how their role enables them to report up and how they can influence senior management if they are employees. We are interested that you will be able to identify your owners and your managers. I appreciate that some of you may not be in a position to identify owners at this stage, but that's something you must have in mind when you're talking to potential investors, that we will expect you to be able to give us that information as part of the application process. You can start to talk to your insurance providers if you're recognised bodies today, or start to talk to the qualifying insurers if you are a new entity about the insurance that you will require and how the process for applying for that insurance should occur. You can start to consider how you will manage, how you will comply with the SRA accounts rules and managing client money if you intend to hold it. In particular, this is important if the applicant is a multidisciplinary practice, where legal services client money must be ring-fenced from any other type of client money. We'll also want to know at the point of application about other employees within the organisation, the numbers and those that are legally and non-legally qualified. None of this comes for free, I'm afraid, and there are fees associated with applying to be an alternative business structure. We have based our application fee on a cost recovery basis, which means that it is the pure cost of the authorisations team being in place to be able to authorise alternative business structures. The fee will be payable at the point that the application is submitted. As Leslie's already referred to, we will be able to submit applications online, and the ABS form will be a fully online interactive form, and the fee will be advised to you at the end of completion. There will also be a cost for each candidate for whom the suitability test is required, excluding those which would be deemed as approved. We may have to charge additional charges or costs for specialist services if they become necessary through the authorisation process. We will make every effort to communicate these to you as soon as they become apparent. However, it would be things like due diligence on a foreign owner or specialist advice on very complex corporate structures. Finally, there is a periodical fee. The periodical fee is paid by the licensed body after the licence has been granted and will be based on the estimated turnover figure which we capture through the authorisations process. So if you're a recognised body today, what can you actually start to do in terms of preparing to be an alternative business structure? Well, you can certainly start to discuss your options with potential business partners. You can explore non-binding arrangements, and you can register company names and domain names. You can enter into exclusive negotiations with potential business partners, and you can take a look at the guidance that's on our SRA website, and you can start to get familiar with the authorisation rules so that you're familiar with the process. You can also contact the ABS team. And we are available to talk to any prospective ABS about their processes and what they're needing to know about either the regulations or how they may set themselves up, and we can give you further guidance and advice on those in those meetings. Moving on to legal disciplinary practices. I wanted to mention legal disciplinary practices because they are effectively a form of alternative business structure with a limited external ownership. LDPs with non-lawyer managers may elect to become an ABS at the point when we are designated as a licensing authority. Alternatively, an LDP can wait until the 31st of October 2012 as the Act and our rules both give you a 12-month transition period. All firms, whether they are LDPs or traditional recognised bodies, must apply for approval of the designated Culp and Coffer by the 31st of March. So I'm going to hand over now to Leslie to summarise and finish off our presentation.
So for all firms, whether or not you intend to become an alternative business structure, there are some steps now which you should take to prepare yourselves for the new world. Firstly, I'd ask yourselves to familiarise yourself with the new rules, not only the Code of Conduct, but also the Authorisation rules and the Practice Framework rules, all of which can be found within the SRA handbook available online. I'd also ask you all to review your current risk management and compliance structures and consider how these are going to work in the new world. Moving on from that, we'd also then ask you to consider who you may wish to nominate as your compliance officers and think about what sort of application you're going to be submitting, and as soon as you're able, log into My SRA. In respect of this final point, the sooner you're able to log into My SRA, the better for you as a firm. It's in your interest, as it will make it easier when it comes to renewing your recognition and practicing certificate this year. I'd like to now talk to you very briefly about timelines. You'll see that this slide contains a lot of information, and I do not intend to go through it all today. What I'd ask you to do is, in your own time, print off this slide. All of these slides will be available online as soon as the presentation is over, and just take a few moments to look at it. Think about where your firm fits on that matrix and think about what you need to be doing now. So, key messages then moving from that. Compliance officers, prepare now. You will need to nominate by March 2012. Please take away the message today that doing nothing is not an option. You need to prepare yourselves for making a Culp and Coffer application next year. Please do log into My SRA. Your passwords will be sent to you over the summer, and I would urge you to do that. And also, consider your position in relation to an ABS. ABSs are not just about huge corporate bodies. They can also be for the smaller firms as well. So consider whether this is a route that you would want to take as a firm. If you've got any questions about becoming an alternative business structure, you may want to contact our ABS team. If you have any questions about the SRA handbook in general, you can contact our ethics and guidance team. And finally, I'd like to signpost some useful links for you. You can look at our document, OFR at a Glance, which is available online, as is the SRA handbook. There has also been a series of webinars, and you can download these if you've not had an opportunity to listen to any of them previously. Related webinars are on the 30th of June, there will be a roadshow recap. On the 7th of July, as Anne's already mentioned, there will be a special webinar dedicated to Culps and Coffers. And on the 14th of September, there will be a webinar talking about our risk centre and how we'll be prioritising risk in the future. So thank you. Thank you for your attention.
The presentation element of today's webinar is now complete, and we are about to begin our question and answer session. I'd like to remind you that in order for you to claim 1 hour of attendance at an accredited CPD course, we do need you to remain with us until the end of the Q&A session. You can now begin or continue to submit text questions and comments using the box provided at the bottom of your screen. Alternatively, to ask a question or make a comment by telephone, if you've not already dialed in, please dial 0203 159 9716 and type "I want to ask a question by telephone" into the Q&A box and stand by to be introduced by the operator. And now, back to our presenters, Anne and Leslie.
I think we've got a question here. So when will the application form be available online, Anne?
Well, for alternative business structures, we have designed quite an extensive application form, but we are unable to make it available on the website until we are designated as a licensing authority. We're hoping that that will be in the summer of this year, sometime in August.
And following on from that, we have another question from Samantha here. How confident are you about being able to meet the October deadline for designation?
Well, certainly from the SRA's perspective, we're very confident that we will be able to meet the 6th of October deadline. The work that my team are undertaking is well into progress, and we are working to being able to receive formal applications from the point when we would be designated in August and issue our first licence on the 6th of October. However, our licensing authority application has to go through parliamentary process, and we are dependent on that parliamentary process. There has been some speculation in the press about whether or not October is still achievable, and we may end up moving that date, but we at the SRA will be prepared to be able to deliver regulation on that date.
I think we have another question here from Shazia regarding the MySRA system, and that is, will I be able to change personal details online, i.e. if there's a name change post somebody getting married? The answer to that, Shazia, is yes, you will be able to change your name online. We may still ask for evidence of that name change in the similar way we do now, which may include a marriage certificate, but yes, all personal details will be changeable online. And I think there's a follow-up question here from Mike about, can we log into MySRA now? You'll be sent a password over the summer which will allow you to log in, but without that password you won't be able to log in, I'm afraid, Mike.
Okay, thanks Leslie. I have a couple of questions here. Question, can a sole practitioner be a COLP and the COFA? The answer is yes, they can. The COLP and the COFA roles can be held by the same person, and the flexibility that we're trying to offer firms is that it is dependent on the size. It may not be appropriate for large 20, 30 or 40 partner firms, but certainly for sole practitioner firms it's perfectly acceptable. And with regard to a question here from David, with regard to the deadline for registration for MySRA, does that apply to the firm or individuals? In respect to the deadline for registration for MySRA, well, it will be part of the online process that you'll be able to log on. There's no actual deadline for registration. We will be sending out your usernames and log-on details, and you'll be able to access your SRA details both for a firm and for individuals. So if you're part of a sort of a medium-sized practice, you may have both your own personal log-on details and one for the firm as well. So you'll be able to go on and have a look at that. In terms of deadline, what we would say is that you should try to do this before the annual renewal process, as this will ensure that all of your details are up to date in the forms that we're sending through.
There's another question here. Will solicitors with a current practice certificate have to go through an authorisation process in the same way as a new applicant? The answer to this question really depends on what sort of authorisation you'd be seeking. If you're already a solicitor, the annual practice certificate renewal process will be much the same as it is now, save for the fact that it will be online. So no, you wouldn't have to go through an authorisation process per se. But what I would say is that if you're a solicitor with a current practice certificate and you wish to become a compliance officer, for example, or potentially even a manager or an owner, then there would be a separate approval process which we discussed earlier, and you may also be subject to suitability test and vetting. There's another question here, one that I think Anne might be able to answer. Can a sole practitioner become an alternative business structure?
Well, to answer the first part of that question, the answer would be no, because the sole practitioner is a lawyer and they are the only owner of the firm. To be an ABS, you need to have some non-lawyer involvement. So you would need to bring somebody else, another partner into the firm who wasn't a legally qualified individual.
And as a follow-up to that question then, Anne, what is the minimum number of solicitors and managers that you'd need to become an alternative business structure?
2, one of each would be the minimum number. So one lawyer, one non-lawyer would make it an ABS. I have a question here about who should you contact in the ABS team. Well, we have an email address, which is the best form of contact. We will respond to you both by email, and we can also give you a call from that. And the email address is, if everybody's got a pen ready, it's abscontact@sra.org.uk. And I have a follow-up question. Will the CULP and COFA have to attend training courses? From the CULP's perspective, if they are a solicitor, then they would need to comply with our CPD requirements already in the handbook, and any other qualifications that the individuals might have, whether they be from a CULP's perspective a barrister or an ILEX, or from a COFA's perspective if they're a qualified accountant, we would expect them to maintain their own CPD requirements. In terms of any specified training courses, we have nothing specified in the handbook, and we would expect, however, we would expect firms to ensure that their CULP and their COFA remain competent to carry out the role.
We've got another question here on CULPs from Robert. Can a legal executive who is a partner in an LDP be the CULP in the new world?
Yes, if they are a fellow of the Institute of Legal Executives, then they can be the CULP. They are classed as a lawyer under the definition in the Act and in our handbook.
Okay, we've got another question here, a three-part question, which I'll try to answer. The question is there any change for authorisation of new practices which are not ABSs, and what's the procedure? Taking that first part, yes, there will be a change for authorisation of new practices. If you're a recognised body, at the moment, what we'd ask is the form that you fill in to become a recognised body is a fairly straightforward form. In the new world, post-March 2012, the application form will be more detailed and we'll be asking more questions, similar to the questions that we'll actually be asking in an alternative business structure. The process for that is currently under design, and I can't give you any more details about it, but what we will be doing is we'll be communicating to the profession shortly about that change of procedure. The follow-up question to that is, how long will the normal authorisation process take? I'm sorry to say that it's almost impossible to answer that at the moment. As I've previously said, the authorisation process is currently under design, so I'm not able to say at the moment how long the process will take in whole. But like I say, application forms will be available online to ensure that our processes are as efficient and streamlined as possible.
Okay, I have a question here about why must a CULP be a lawyer? And the requirement for that is actually set out in the Legal Services Act, and the Act also sets out the requirements of what it defines as a lawyer, and effectively the Act sets out that a lawyer must be approved by one of the authorised to undertake one of the reserved legal activities by one of the approved regulators, which are listed in the Act, and those have actually been increased recently. ACCA has become one of the approved regulators for the purposes of probate activity. So it is a requirement of the Legal Services Act, and we have just copied that over into our rules.
And there's another question here related to COFAs. Jones asked, does this person need some form of certificate in accountancy, or would a number of years of practical experience be sufficient? I think the answer to that is no, you wouldn't need a particular certificate of accountancy. What we'd look to see is what experience you do have to ensure that that is sufficient. And do you have anything to add to that?
No, I absolutely agree with you, Leslie. That's exactly what we'd be looking for. We would look for the experience, and we would look to ensure that you were competent to do the role. Okay. I have a question here, and Leslie, I may need you to help me answer this, but can a firm register the accounts of all their solicitors and coordinate payments for practice and certificates? My understanding is that the renewal process, which will be online this year, will enable firms with large numbers of solicitors to be able to effectively do a bulk renewal for those certificates.
Yes, that's absolutely right. You will have your own MySRA space, but similarly to what happens now, firms will be able to bulk renew.
Okay. I have a question here. Approximately how much do you expect the initial ABS application fee will be for small firms? This will be a factor in deciding whether to apply. I absolutely do agree that the fee will be, certainly for smaller firms, will be very important in the decision whether to apply. We're not in a position to be able to confirm exactly what that fee is going to be as yet. We're in the final stages of putting that to the SRA board, and that will be going to the board in the public session in July, and then will be communicated to the wider population. So I'm afraid at the moment it's a watch this space, as it needs to be approved by the board first.
There's another question here. What is the suitability test for the non-lawyer in an ABS? Sorry, Anne.
Sorry, I jumped in there, Leslie. The suitability test is exactly the same for the non-lawyer as it would be for the lawyers in an ABS. So for the culp and the coffer, it would be the requirements to answer the questions with regard to criminal behaviour, financial mismanagement, and we would be undertaking checks of the information that we are given. So all of the aspects of the suitability test covered in the handbook at page 394 would be asked of the non-lawyer.
Thank you. We've got another question here about, would a sole practitioner be required to have a culp and a coffer? I think the important thing to remember about a culp and a coffer, we see those as roles within a firm. They're not necessarily job descriptions. If you are a sole practitioner, you would not necessarily have to employ any additional people to act as a culp or a coffer. You could be the sole practitioner and fulfil the roles of a culp and a coffer as well. So you don't have to worry about having to employ lots of additional staff. Of course, when you're putting in your nomination to be a culp and a coffer, we will look at your application form in some detail, as we would with any other firm. But like I say, there's no bar on a sole practitioner being their own culp and a coffer. A follow-up question, when will firms have to submit business and compliance plans as part of the authorisation process? Again, for recognised bodies, the process for becoming a recognised body post-March 2012 is currently under design, and it's not entirely clear that such business plans will have to be submitted. But I think for alternative business structures, Anne's already answered that question.
Yes. In terms of business plans, we won't be asking for them, but we will be asking for information which would commonly appear either in a business plan or derive from some sort of business planning activity, like estimated turnovers, profit and loss, and growth plans.
I think we've had another question as well about how long will the authorisation process take under the new regime. As I previously said, that process is currently under design at the moment, but what I'd ask you to do is have a look at the authorisation rules. What you'll see in there is that applications have to be dealt with within the SRA within 6 months of the SRA receiving all the information we need in order to look at an application. The SRA can ask for an extension of up to 3 months of that. But if after that total decision time the SRA has not given you an answer, then that's a deemed refusal and you can apply against that decision. Now, what we don't know is how long that process will take at the moment, but as I've said previously, what we're hoping is that with the introduction of the online applications, that the process will be as streamlined and efficient as possible.
Yes, and Leslie, I'd just like to add there that it's very much in the interest of firms applying to ensure that they do give us full and complete information, because the things that are likely to hold up the authorisation process, whether it be for a recognised body or for an alternative business structure, are when we undertake some sort of investigation around the information we are provided with, only to uncover further questions and further issues because we've not been given the full picture. So it's very much in the interest of firms to provide us with as much information as possible, and that's why from an alternative business structures perspective we are talking to firms who want to apply, and we are available to talk to firms who want to apply. to enable them to understand exactly what we do need as part of the authorisation process.
That's right, Anne. Thank you for that. We've got another question here about compliance officers, a popular subject today. Does the COFA have to be full-time? Anne, do you want to deal with that?
Yes, Leslie, I will. No, there's no requirement in the rules for the COFA to be a full-time, whether that be a full-time role within the firm or whether or not it's simply a part-timer who only comes in for X number of hours a week. What we would be looking at in terms of the assessment to approve that, that structure and that individual is whether or not there is sufficient time available to that individual for them to be able to fulfil their responsibilities. And if we felt that it wasn't a role that they would be able to fulfil adequately in a part-time on a part-time basis, we would enter into a dialogue with the firm to see resolve that.
Sorry about that little bit of interference there.
Okay. I do have an additional question here. Is it acceptable to delegate some of the COLP or the COFA functions? Well, in theory, yes, it would be possible to delegate some of the function of the COLP and the COFA, and in my team we have talked to firms who are considering offering that service to the legal community. What we would be looking for, though, is to ensure that that delegation was very clear, and we would be looking to ensure that the individuals picking up the post were able to competently fulfil it. In addition, I would make this point, though. It is not possible for the firm to delegate the responsibility. They may delegate the action, but they cannot delegate the responsibility. So it will be the firm who are ultimately responsible for compliance with the handbook. Okay, so I think now we have a telephone question from Paul Hampton. Paul? Are you there, Paul? Paul, if you can hear me, can you press *1, please, and ask your question?
Hello, can you hear me?
Hello there, Paul.
Can you hear me?
We can, yes.
Yes. Hi, I'm a sole practitioner, and the question which is not clear to me, which is probably similarly not clear to other sole practitioners, is how much work would be involved if the sole practitioner performs the functions of COLP and COFA on his own for his practice. Essentially, a sole practitioner's work is in a small compass normally if he doesn't employ anybody. And how much extra work would that involve? Well, how much time would be involved in fulfilling those functions?
Well, I think I'll certainly have a go at answering that for you, Paul. The way we view the COLP and the COFA roles is that they are no more than firms who are currently complying with our current code are already doing. So as a sole practitioner, you have various requirements under the 2007 code which you need to comply with. You need to look after your and ensure you're complying with the accounts rules, etc. So we don't envisage that there would be any additional work, providing you look at the way you are undertaking your compliance at the moment and feel that you are fully compliant with the current requirements. There would be no additional work with the compliance officer roles. It's simply something you're already doing as a sole practitioner.
I think that's right. I think if you look at the current Rule 5 of your Code of Conduct, and under Rule 501 it lists a series of things that firms should already be undertaking in terms of understanding risk, managing compliance with the handbook. If you're already doing all those things, as I'm sure you are, you will have already effectively been doing a COLP and a COFA role as we envisage. So I hope that's giving you some comfort there.
It has. I was terrified.
Thanks for your question.
Thank you.
Thank you. Okay, so
we've got a question, an interesting question here from David. What are the penalties for non-compliance? Well, of course, the authorisation rules, once you have a look at them, it doesn't talk so much about penalties for non-compliance, but what I'd remind you of, and what I'd remind everybody of, is similarly, regulatory obligations are mandatory. And under the Code of Conduct, including the new Code of Conduct in the handbook, if you fail to comply with regulatory obligations, that may be considered as misconduct. There is no structure for if you don't do X then Y will happen, similarly to what happens now actually. But what I would say is that, as I'm sure all of you already do, please take compliance with the authorisation rules seriously.
Okay. Now, I think I have a question here from Philip. In future years, will law firms be asked to provide more detailed information at renewal about their business and client types over and above what is required now? I think if I can, to start to try and answer that, and Leslie, I'd invite you to step in if you have anything to add. But Philip, yes, I think it is possible that we will ask for more information, but it will be driven very much on a risk basis. So we will look at the information we currently hold about firms, and we may be asking for less of the current information, and we might be asking for more new information. But that is all going to be part of the growth of our risk-based regulation over the coming 12 months as we become more familiar with the approach of an OFR regulator.
That's absolutely right, and I think what I'd just add to that is that I spoke earlier about the annual reporting exercise that will replace the current annual renewal exercise. It will be at annual reporting time that if we want more information from you as a firm, that's the time when we'll be asking for it.
Okay. I have a question here. As a potential ABS, we have barrister managers and owners as well as solicitors. The BSB say they will have to comply with rules and guidance to be issued, but there is no sign that the BSB are working to October as a timetable. If there are no rules, will the SRA approval be okay? Now, yes is the answer. If the ABS itself, if the firm ABS is regulated by the SRA, then the individuals there will be authorised by the SRA as well. So if you have a barrister manager, they will be approved by us as part of the ABS firm, which is regulated by us. We will also expect that barrister to comply with their own code of conduct and ethics, etc., and to hold their own practice certificate or their equivalent within their own regulatory framework. And we will liaise with the BSB to ensure that there is limited regulatory overlap. So I hope that answers that question, but essentially the SRA, if it approves the ABS firm, will automatically, as part of the application process, be approving the barrister managers.
And on a similar theme there, we've just got a question come in. Does an LDP comprising solely of solicitors and Filex legal executives partners have to convert to an ABS? Are you able to deal with that, Anne? As an LDP, which is sole practitioners and Filex individuals, that's not a legal disciplinary practice with non-lawyer managers, and it's only non-lawyer manager LDPs that have to convert to an ABS. Thanks, Anne. I've got another question here from Jane about culps and coffers again. And what Jane says is, presumably it will be sufficient to have an understudy or delegate for the culp and coffer in firms where they are absent. I think, Jane, there, the question you're asking is when the culp and coffer goes on holiday or absent for sickness, anything like that, is it okay for somebody to stand in and do their role? At the SRA, we do accept that people need to take annual leave. I'd like to say that first of all. And it will be sufficient whilst that person's on annual leave that another person can stand in as a culp and a coffer. Just as a point, a firm can only have one culp and a coffer. So a firm cannot have 2 or 3 delegate nominated culps and coffers. So, and obviously one person will have to be absent for annual leave or what have you. So yes, it will be sufficient for someone to step into their shoes. If, however, a culp or a coffer leaves unexpectedly, the firm can apply for a temporary emergency approval or application of somebody to step into their shoes whilst the full approval process goes on.
Okay, and I think we have time for just one last question, which is why should ABS be regulated by the SRA and not other bodies? Well, it's a very good question. At the SRA, we believe, and by moving to risk-based, outcomes-focused regulation, that we wish to be the regulator of choice for the legal profession. However, it will be open to alternative business structures to apply to any licensing authority. Just to put that into perspective, though, at the moment there is an application being submitted by the Council of Licensed Conveyancers and the SRA, and none of the other approved regulators have currently applied to be a licensing authority. So the choices will be the CLC or the SRA. And when considering the choice of regulator, obviously there will be many factors, but one in particular should be what reserved legal activity you intend to undertake. Because if it's obviously a legal activity which the CLC are not approved to be able to regulate, then the SRA would be your next choice. I'm sure there are other approved regulators who are intending to apply to the Legal Services Board, but as yet they haven't made those applications. Okay. And so I think that draws us to a close. I'd like to thank you all for dialing in and listening to us today, and for those very varied and interesting questions. And thank you very much for today.
Thank you.